Hello, everyone. Finally, we're here with the revision series as you all have been waiting for. So, CMA Final Law, we are going to revise all the chapters one by one. So, I'm going to start pushing the videos, pre recorded videos of every chapter revision, right? Every chapter, that means every chapter. So, there will be 100% coverage. But this particular video is going to be in 100% English language. We have revision for CMA Final Law in both the languages. So, if you're looking for English classes, a mix of Hindi and English, go to a separate playlist that we have created and you can find the videos therein. So, in a span of every 3-4 days, you can expect the video of another chapter live. But before I say anything else, please subscribe the channel if you haven't yet subscribed and press the bell icon so that you stay notified, you stay updated with all the new videos, all the new information coming your way for your relevant for your CMA final examination, especially law. Now, this particular video is only meant for revision purposes, right? So, if you look at my regular or comprehensive or exam oriented batch that I take, we have a set of 6 books wherein there are 2 books which are class notes, then there are question banks, and then there are chart books. Okay, so first we have or gain that conceptual understanding through our main book. Thereafter, we practice question through question bank, and thereafter, we revise through the help of chart book. Okay, so this is the revision part, that quick revision part that we are doing. Of course, it covers, and I have tried to cover as much as possible, even in these revision series. But then, this is not a replacement to your full course. Okay, so if you're looking for that full course classes, if you haven't gained that understanding yet, please, you can visit our website bookmyvideo.in and you can subscribe to our classes, because this is not going to replace that original gaining of knowledge and understanding, right? So let's begin. And of course, our classes are CMA exclusive only, so no mix and matching. So according to CMA Institute syllabus, we have designed our classes. I take classes, and these revision classes are also CMA exclusive. Okay, so don't worry on that part. There's no copy paste, nothing. You don't have to be worried. I hope this turns out to be useful and helpful to all of you. See you in the next class and enjoy this. We are going to commence with the chapter wise revision, right? Thank you. Let's now revise the chapter of company formation and conversion. Now, if we begin, it is all about Companies Act, right? So, Companies Act 2013. But before that, one more thing, important thing that you need to know from examination perspective, especially for objective type of questions, is that what was the first structured company law? It was Companies Act 1913. See, three important Companies Act or company law that you should keep in mind is Companies Act 1913. Thereafter, Companies Act 1956, that is the first Companies Act of Independent India. And thereafter, Companies Act 2013, which ideally is divided into 29 chapters, has 470 sections. Although I would again say, ideally, if you look, it doesn't have 470 sections, it has more sections. Some sections are deleted, some amended sections are added, but eventually the chapter or the act came up with 470 sections, and it has 7 schedules, right? So what is all about Companies Act, ma'am? For that, we need to first understand and know what company exactly is. So, before I proceed and go to the definition of company, Companies Act 2013, the very first chapter, has only 2 sections. Section 1, which talks about short title, extent, and applicability, and section 2, which has the definitions. But before that, this Companies Act, it is administered by whom? We all know that in law we have an executive body, and executive body, or whatever law is made, it is made by the legislation, that is central laws or central acts are being made by the parliament. However, to execute those laws, it is the responsibility of central government. That is, central government is the executory body. So central government executes or administers through its ministries. The corporate law or companies are being administered by Ministry of Corporate Affairs. So ministry is the Ministry of Corporate Affairs, that is MCA. Thereafter, we have two important authorities. The two most important authorities are ROC, Registrar of Companies, which actually undertakes the task of incorporating the companies, for administering the registered companies. And we have NCLT, which has actually replaced the courts. So for corporate courts, it is like NCLT. If you want to appeal, you have NCLAT, that is National Company Law Appellate Tribunal, right? So these are basically the important authorities that you need to keep in mind to proceed with the chapter, right? Other than that, we also have official liquidators, but that is something which is not needed as of now. Now, what do you mean by company before we actually switch to Companies Act? Company is being defined in Section 2, Clause 20 of the Act. What is company? If you go by the general meaning, it is just another form of business organization, a group of voluntary people who are coming together and they are working for a motive, and they have chosen this particular form of business organization. Or if you choose this particular form of business organization, that is company, you have to register yourself under Companies Act, because under Companies Act, only the companies which are incorporated under the act of previous company law are company. Okay, so incorporation or registration under the act is something which is very important. Apart from that, company has a lot of features, right? The general features which we have read over and over again. So, one more time, we will revise it. The very first one is independent corporate existence. What is it? It is separate legal personality. The case of Salomon versus Salomon and Company, that you can keep in your mind. So, the company is different from its members. The company has a separate entity. The company is separate in the eyes of law, and the members are separate. This also goes on to establish a wheel of incorporation, that is corporate wheel, which gives the benefit to its members that whatever default is happening or whatever problem occurs, it is the company which has done and not the members which have done, or not the members who are actually running the company. So that this independent corporate existence also establishes a wheel of incorporation, which may be lifted in certain cases, which we'll come to later. Okay. Second one is limited liability. What is limited liability? One of the biggest advantages of forming a company. Supposedly, you have formed a proprietorship firm, and thereafter you're running your business. You took a bank loan, and eventually maybe you could not pay that bank loan. Now you don't have funds in your business to repay the bank loan. Your personal assets can be attached, whatever bank balance you have in your personal account, or maybe you have a house, that can also be attached, right? So it does not create a separate entity. You both are same, and that's why your liability is also not restricted to just what you have invested in the business. Here in the company's case, your liability is restricted. So this is the principal advantage of doing business in the form of company. So whenever you choose to register a company with a limited liability, because a company can also be registered with unlimited liability. So if you have registered your company with a limited liability, then what will happen is your liability is also limited. Limited to what amount? It depends whether the company is of share capital or a guarantee company. If it is of share capital, it will be limited to the amount unpaid on shares held by you. Right? If the share price is 10 rupees and you have just paid 6 rupees, so your liability is limited only to 4. That is the unpaid amount. And in case of guarantee companies, whatever amount you have undertaken, whatever guarantee you have taken, right? Next is perpetual succession. What is perpetual succession? It doesn't matter who comes, who goes. Today you may be the member, tomorrow somebody else may be the member. It is not going to affect the company. Just like a partnership firm, it gets dissolved if a partner leaves, and then you have to re-establish the same if you want to continue, if you add whatever it is happening. But here, company, it will be intact. So membership may keep on changing. It does not affect the company's continuity. Next is separate property as separate owner. Because you have been recognized as a separate person in the eyes of law, you are a legal person, you can have the property in your own name. You can buy some property, you can dispose it, you can sell it, you can mortgage it, you can enjoy the features, you can enjoy the benefits of owning a property or transferring it, right? So you can have that. Next is transferability of shares. Now, transferability of shares, we have two types of companies, public and private. In private company, the shares can be transferred, but they are restricted. In public company, they're freely transferable. In both the cases, they are capable of being transferred, right? Whether restrictive way or freely, they are capable of being transferred. So if you have invested in a company, maybe in the form of shares or maybe in the form of debentures, or you have any interest in the company, that is a movable property. Shares are a movable property, debentures are a movable property, and they can be transferred from one person to another. So that means you can easily be sure that, okay, if this investment doesn't work out, or if I'm in dire need of funds, I can always withdraw this money by transferring it to someone else, right? So it also provides liquidity. Your funds are not as if they are blocked and they can never be released. No, they are liquid funds. Next is common seal. Although common seal has become optional, earlier it was mandatory. After Companies Amendment Act 2015, it has become optional, right? However, if the companies have common seal, there is a proper procedure which has been given how to keep common seal, in whose custody it should be kept, and how to utilize it. If the company doesn't have common seal, then the authorization can be done by two directors, and if the company has company secretary, then it will be also be done by one director and a company secretary. Now we come to the next concept of lifting of corporate wheel. Corporate wheel, I've already explained you. What do you mean by lifting of corporate wheel? See, sometimes it may so happen, because company is an artificial person only. We all know that whatever company is doing, supposedly company has taken money from the creditors and is not repaying the money. It means, if this is happening in the normal course of business, fine, the company is different and the persons who are running the company or the members, they're different. However, if this is a case that people are doing fraud, then this fraudulent mind is human mind. So who are the real persons who are actually running the company? We need to look behind, right? So in some cases, this wheel of incorporation, this curtain, this has to be lifted. This has to be lifted, and we look behind the real persons, right? This is like, the people are wearing a mask, and this mask has to be removed, right? So wherever law ignores this particular wheel of incorporation, when they'll ignore the concept of separate legal entity and look behind the real persons, who are the real managers, who are the real members who are actually responsible for this particular act which has happened, then that is what is called as lifting of corporate wheel. We have two types of cases. We have one statutory cases and one judicial interpretations. The statutory cases we don't have to read here separately, because over the period of time when you eventually read Companies Act, you come to know about that statutory cases. Example, misstatement of prospectus. So if you are showing, if you're giving an offer to general public by giving some incorrect information, and people are actually subscribing to your securities based on that information, well, you have cheated that people, and a company cannot cheat. So this fraud has been done by persons who are actually running the company. So in such case, the corporate wheel is lifted, and Companies Act actually penalizes the people who are responsible for authorizing that prospectus. So such type of cases are covered in Companies Act. However, here we are talking about the judicial interpretations. There has been many cases in the past where the courts have taken this decision that no, we need to lift this corporate wheel and look behind the real persons for certain situations. We have case laws associated with it, and we have already explained you here. I'm not going to explain you each and every case law, but of course we will look at the situations. The very first one is trading with enemy. A lot of times it happens that to identify whether a particular entity is an enemy or not, you need to lift corporate wheel, because a company may be incorporated in India. So it looks like an Indian company, but it has been incorporated by people of England. So if India is at war with England, then England becomes our enemy, and the company which is being run by England's, that should also be our enemy. However, it is an Indian company, so company different and members different. Concept won't work over here. So when we want to check whether a particular entity is our enemy or not, we need to lift this corporate wheel. So courts have done that in the past. The very first one, laws of taxes and duties. If you are trying to evade the taxes, so wherever the matters of laws and taxes and duties stamps they are concerned, then of course the corporate wheel is going to be lifted and it is going to be merged, and accordingly you have to pay the taxes. Avoidance of welfare legislation, the famous case of rubber industry. So what happens is, you are trying to avoid, maybe you are trying to avoid bonus, you are trying to avoid payment of bonus, and for that you have formed another entity. No, you are going to be merged, you are going to be this is going to be lifted, and actually you will be look behind. To protect public policy, simple one, transfer of shares of company which actually was a sale of land. So this is a specific case where it wasn't allowed, that land transfer wasn't allowed according to the law. So you transferred the shares, which eventually led to the sale of land. So this is something which was not allowed, and the Supreme Court in this case actually lifted corporate wheel. Last one is formation of subsidiary to act as agent, where the companies form other companies to act as their agent. In such a case, the corporate will be lifted. Although subsidiary and you will be different, but here the corporate will be lifted. So these are the general cases that we have. Next is nature of business organization on the basis of government ownership. Now, what are we talking about over here, ma'am? See, we are not talking about all the types of business organizations that we have in India. We are talking about those business organizations in which government is making an investment. So, government may make the entire investment, or may make a huge investment, or may make lesser investment also. Usually, in whichever sector government is making an investment, is usually tends to be the sector which the society needs. Like railways, we all need some medium to commute from one place to another, and if this railways will be entirely privatized, maybe it will be difficult for people, it will be difficult for the common people, or for the lower class people to actually commute, because if it is privatized, maybe the rates, maybe the fares will go up, because it is not going to run into losses, right? So usually profit is not the motive of government investment, it is the motive is to cater to the needs of society, right? It is divided into two sectors on the basis of government ownership. One is the public sector and the other is the joint sector. Public sector, where government has made huge investments, and joint sector, where the government has invested from about 26 to 50%. More than 50% comes in this particular case. Now we have government departments like railways, postal, etc. We also have statutory corporations like RBI, LIC, SBI, etc. And we also have government companies. So when we read section 2 clause 45, we come to know what government companies are. The companies which are incorporated under Companies Act or previous company law, in which 51% or more stake or shares or voting power is held by central government or state government, or a combination of them, is called as a government company, right? So public sector is divided into these three. So a short note may be asked on this. Now, apart from this, when we come to the classification, companies, we look and we read a lot of type of companies, government companies, as we just saw, dormant companies, nidhi company, small company, private company, public company, listed company, unlisted company. So we have read about this so many times. So yes, companies are going to be classified on different basis or criteria, like you can say on the basis of number of members, private, public, OPC. or the basis of control, holding subsidiary, associate, right? So we have such type of classifications, and we are going to start and read the same. But before that, since we are now going to switch to section 2, what is section 1? I already told you. Companies Act is going to be applicable on entire India. Companies Act is going to be applicable on companies which are incorporated under this act or previous company law, banking, insurance, electricity. So far, the provisions are consistent with their respective specific regulation. If there is any inconsistency, then the specific law shall prevail over this one. And it is also going to be applicable on any other body corporate which government may notify, like NHAI, FCI, National Highways Authority of India, which has been notified that okay, you are a body corporate, but on you Companies Act will be applicable, right? So such type of body corporates may also be notified on which applicability shall exist, right? Now you have to form a company, and thereafter this particular classification comes. But because we are going to talk about incorporation at a later point of time, then I will discuss with you promotion. How do you actually incorporate or promote a company? Fine. So let's first have a look at the definitions. We're still into the preliminary chapter of Companies Act. Okay, we're actually beginning the preliminary chapter, that also you can say. So the very first one, private company. I'm reading it in the sequence it is given with me. Okay, so on the basis of number of members, Section 2, Clause 68, private company. What is a private company? Which has minimum 2 members, maximum 200. So it is a company which limits the maximum number of members up to 200. However, when we compute this particular limit, what is not going to be included? The employees, present and former employees. They are not going to be a part of this 200 limit. Moreover, the joint holders are going to be counted as 1. Okay. Then minimum paid up capital as may be prescribed. Nothing has been prescribed. Now, the most important thing in this definition is this part. So, in the articles of association of every private company, there will be a restriction on transferability of shares. That means shares can be transferred but not freely. There is a prohibition. Prohibition on what? Prohibition on invitation to public. So they cannot invite public to subscribe to its securities. You can never make a public offer. And third is limitation, as I already told you, right? Every private company has to add a suffix, like private limited, of course. And OPC and small companies are also a kind of private company only. OPC is also a private company, and small company, which we look at, they are also a private company. See, if I go on to see section number 3, if you are trying to form a company, if you're trying to incorporate a company, there are 3 ways or 3 types of companies which may be incorporated. The first one is private company, the second one is public company, and the third one is OPC. There is no other type of company which can be incorporated. Ma'am, what about government company? See, government company also, if you want to incorporate, it will be either private or public. Ma'am, small company is nothing but it is a private company which meets certain criteria, so it gets benefit of being a small company, right? So every company which you're incorporating has to be private or public, right? Some companies are allowed this way, some companies are not allowed this way, but it is going to be like this only. Banking company, it has to be that. So first prima facie you have to select this only, private, public, or OPC. Okay. Next is public company. Now, public company definition is even more simplified. What is it? Which is not a private company. So the number of members, minimum 7, maximum there is no limit. And if I talk about the directors, minimum there are going to be 3 directors in a public company, maximum 15 directors, which of course can be increased with a special resolution. In private company, minimum there can be minimum there has to be 2 directors, and maximum again 15 directors. In OPC also, minimum there is just 1 director, and maximum there is 15 directors. So maximum 15 director in all the cases, minimum 1, 2, and 3. Okay. Now, public company, paid up capital as may be prescribed, nothing has been prescribed. Unlike private companies, in its articles, there is no restriction or prohibition. That is, you can say the shares of a public company are freely transferable. One important thing or one distinguishing feature, which over here you'll find, is this: subsidiary of a public company will be deemed public company. No, what do you mean by this? Supposedly, you have a company ABC Limited. It has a subsidiary PQR Limited. Then PQR Limited will be a public. It is a public company only. Okay, so let's change the example. You have ABC Limited. It has a subsidiary PQR Private Limited. Now, this PQR Private Limited is going to be deemed as public company. That means, ma'am, it will convert itself into a public company? No. Ma'am, it will change its name to and remove private? No. Ma'am, it will change its articles? No. Then what is going to happen? It will comply with all the requirements, all the compliances that a public company has to make. That means all the benefits and exemptions which a private company was enjoying, that will go away because you are a part of that group, right? A public company has invested money in you, so you also have to give that proper disclosures, adequate transparency, etc., etc. Everything comes into play. Okay. Next is one person company. What is one person company in which there is one member only? So minimum one and maximum also one. So it is a private company with just minimum one member and maximum one member, and minimum one director, maximum 15 director. One interesting or different feature is what? To ensure smooth perpetual succession, I would say, you have to state the name of a nominee. You have to state the name of a nominee who is going to be stated in the memorandum of association. You have a special succession clause wherein you will write the name of nominee, and that particular person is going to take the place of sole member in case sole member dies or he becomes incapable to enter into a contract. That means what is happening, ma'am? Ma'am, there is a company which is being formed by just one person. Ma'am, what person? Can a company form another OPC? The answer is no. Ma'am, in case of private company where you need two members, can it be a company? Yes, it can be a company. A company can form another company. A company can be a member of another company. That's not the problem. But a company or a body corporate cannot be a member of OPC. Why? Because in OPC, there will be just one shareholder, one member, and that particular member has to be a natural person and an Indian citizen. It is not mandatory that he be the resident also. Earlier, resident also was needed. Now it is not needed. So if you read it, you're reading the older law. Okay. So resident is not required. That particular person can incorporate OPC. Fine. Now you will also appoint a nominee. Nominee will give your consent. A nominee also has to be natural person, Indian citizen, whether resident or not. Okay. Basically, this concept was introduced to promote the budding small entrepreneurs who were running the proprietorship, to give them the corporate status, to give them the benefit of limited liability. This concept has been introduced. This concept is something which is new to India, although in India also there was a concept of one man company before. But this particular concept has been very old in countries like China, Australia, UK. Okay, now we have introduced it. Moving to the next segment, that is on the basis of control. On the basis of control, we have a holding company, we have a subsidiary company, and we also have an associate company. Holding company definition is very simple, and once we understand the definition of subsidiary company, then it is better to understand the definition of holding company. Anyway, they are relative terms. I always say that if I am a mother, I am not a mother to everyone. I am a mother to my child, right? So we share this relationship. Likewise, if I say holding doesn't mean you are holding to everything. No, you are a holding company to your own subsidiary. So subsidiary is subsidiary to its holding, right? So it is a relative concept. These are relative terms. It can always be understood in relation to some other company. So subsidiary company in relation to some other company, a holding company either controls the composition of board of directors or controls more than half of voting power at own or together with its subsidiaries. That means if I say we have ABC Limited and ABC Limited holds. See, it's written more than half, so it could be 50.00001% also holds this percentage of shares of PQR Limited. So I can conclude that PQR Limited, you are the subsidiary, and ABC Limited, you are the holding. Yes or no? Yes, ma'am. Now they are controlling more than half voting power. Voting power is as good as shareholding unless you have DVR, that is differential voting rights. So right now we are considering a normal case only. At own or together with its subsidiaries. Now there could be another case. What could be the other case? ABC Limited is holding only 20% shares in PQR Limited. That means this does not make PQR Limited its subsidiaries. However, ABC Limited is holding 70% shares in XYZ Limited. Now, this XYZ Limited holds 40% shares in PQR Limited. That means XYZ Limited is a subsidiary of ABC Limited. That is something which is established by this. Yes, ma'am. Now, ABC Limited together with its subsidiaries holds 20 plus 40, that is 60% shares in PQR Limited. So ABC Limited becomes a holding to PQR Limited also by this particular point at own or with its subsidiaries. Right, so you could also control composition of board of directors or exercise control in such a manner. In both the cases, you will result in becoming the subsidiary and the other company will become a holding company. Okay, now there is one restriction that a company cannot have more than two layers of subsidiaries. Although in the section we just find that holding companies as may be prescribed shall not have layers of subsidiaries beyond numbers as prescribed. The number prescribed is 2. Okay. Moving to the next part, that is associate company. In associate company, it is actually somewhere in between. So you are a holding company, or let's not get into the concept of holding. You are a company, ABC Limited. You hold 30% shares of PQR Limited. So holding 30% shares does not make PQR Limited your subsidiary. So it is not your subsidiary. However, since you are holding shares more than equal to 20%, either 20% or more than that, you are having significant influence on the other company. So if one company has significant influence on the other company becomes your associate, right? And you become ideally the investing company. Okay. Right. Joint venture is also included in the definition of associate company. Now, small company. Small company, the most debatable company I've ever heard. That's because government has been constantly changing the prescribed limits, and that's why students have this knowledge of small company. They might not know any other company, but they'll definitely know small company. Anyways, you have to understand the entire concept relating to small company and not just this 2 crores, 20 crores, 4 crores, 40 crores, 50 lakhs, 2 crores. No, what is actually a small company? A private company. That means a public company can never become a small company, first thing. If you are a Section 8 company, you cannot be classified as a small company. You will not be conferred benefits or exemptions of being a small company. Thereafter, if you're a holding company, if you're a subsidiary company, or if you're a company which is governed by some special act, like banking company, then also you're not a small company. Now, other than that, Other than that, if you have a paid up capital which does not exceed, that means it could be that amount or it could be lesser than that amount, it should not exceed 50 lakhs or such higher amount as may be prescribed. Government has the power to prescribe maximum 10 crores, up to 10 crores. Government cannot prescribe more than 10 crores, that amount. Has government prescribed anything? The answer is yes. Government has prescribed the amount to be 4 crores. Government has prescribed that amount to be 4 crores. Okay. And the turnover, if you comply with both the conditions, then you will become a small company. So twin condition compliance is there. It is not an or was there long back. Now it is an and turnover should not exceed 2 crores or such higher sum as may be prescribed. Okay, the amount prescribed is 40 crores. Maximum 100 crores can be prescribed by government. Now, the problem with the students is that if they are being asked what a small company is, some students write it this way: a private company whose paid up capital does not exceed 4 crores and turnover does not exceed 40 crores. Well, this point is correct if you want to identify whether a company is a small company or not. So if you want to check whether this company is a small company or not, all you need to see is 4 crores, 40 crores, and that's it. Both conditions comply, yes, you're a small company. However, when you want to write an answer, and if you look at your institute's material, they don't even give you this prescribed amount. They are concerned with the section. So they haven't given you this amended all that part. No, they haven't given. So if you don't write this, will you get answer? The answer is no. You have to understand the entire section and you have to write that entire section. You get my point? Next is Section 8 company. What is Section 8 company? Section 8 company is a company which has been formed for charitable objects. Okay, so here minimum directorship requirement is not there. It is a company which has been formed for promotion of commerce, art, sports, science, culture, environment, etc., etc. For this, you need to obtain license from central government, and this license can be revoked also. We'll come to that cases later. Whatever profit you're generating from a Section 8 company, they cannot be distributed as dividend. You have to utilize it for promotion of these objects only. So if you have formed a Section 8 company like Reliance Foundation, maybe for a particular purpose, for whatever purpose you have formed it, you have to utilize entire money that you're being generated, surplus, whatever, for the promotion only. Okay, and it is not required to use limited or private limited, rather, as I suggested, the word foundation, maybe the Reliance Foundation. Okay, government company, I have already explained you, right? And ONGC, right? So the only additional thing is company in which at least 51% of paid up share capital is held either by central government, state government, or jointly by both. And if there is a subsidiary of a government company, then that subsidiary will also be a government company. Okay. Foreign company, I'm not going to explain it to you right now because we have a separate topic later on. So I will deal with it later on only. Okay. Now, dormant company. What do you mean by dormant company? See, dormant company is a company which is not working right now, which is inactive, right? Inactive in a way that it is not doing any significant accounting transactions, or maybe you have formed a company, you are a college student, you have formed a company, you have no intent to do any business right now, but you have just formed a company because you wanted to hold an asset, right? Or an IP, or maybe you have developed a formula and you have got it patented, you want to hold that in the name of the company. So you have formed a company, but you're not doing any business over here, right now. So in such a case, what happens if you have formed a company for future project or to hold an asset, and you're not doing any significant accounting transaction, then you can apply to ROC and obtain the status of being a dormant company. The second case, if right now you formed a company, you started business, but at some later point of time you become inactive. So now you're an inactive company
Now you make an application to ROC and obtain the status of being a dormant company. What is being an inactive company? Inactive company, if you don't have any business in last two financial years, or no significant accounting transaction in last two financial years, or non-filing of financial statements and annual return in last two financial years. Okay. Now, some other types of companies which we have not read before. Statutory company and registered company. See, statutory companies are not actually companies, they are body corporates only, which are not formed under Companies Act. Okay, so it is a body corporate which has been established by some special act of parliament like RBI, LIC. What happens? We have an LIC Act. Under LIC Act, there is a body corporate which has been established, which is LIC. So it is not incorporated under Companies Act. So it is also commonly called as statutory companies or other body corporates, whatever you may call. Registered, the ones who are actually defined in Section 2, Clause 20. So in Section 2, Clause 20, you have a company, and the companies which are incorporated under Companies Act, they are called as registered companies. Limited by shares and limited by guarantee have already revised. Unlimited, which does not have any limit on the liability of its members. Now comes your listed company. Listed company. What do you mean by listed company? See, one thing, a company is the never being listed on recognized stock exchange. It's the securities which are being listed, right? So if there is any company whose any security is listed on a recognized stock exchange, then it is called as a listed company. Now what happens is, if what is recognized stock exchange? It is a marketplace, right? Or it is a platform where you get an opportunity that, okay, I am a company, I'm issuing shares, that means I'm raising funds from public, and in turn I'm giving shares to them, right? Shares is just a proof that, okay, you have invested this much into the company and you are a holder of these much shares, right? Now, if you want to sell this share to someone else, if you want to withdraw that investment, as I said, they are liquid funds. So, how will you do that? How will you do that? You might have to go to a bank, you might have to go and find a prospective buyer, and thereafter you'll execute a transfer deed, and that is going to happen, right? It is fair enough in case of a private company where there are limited members, but when a company has made a public offer and there are so many people who are involved, then you need to provide them a platform where they can actually come and sell their investments or later on buy whatever they want to, right? So a company, before making a public offer, has to approach that market platform, that stock exchange, any stock exchange. Supposedly you have approached NSE and you are getting that particular shares which you're going to offer to public being listed on that stock exchange. So you get them listed over there, and you have provided a platform to them. So you have listed your shares on that recognized stock exchange. Yes or no? Fine. Now, when you get that listing done, the people are coming, they are buying, they are selling, everything is happening. That's fine. Sometimes it may so happen that you are not actually listing the shares that you have offered to public, but you are listing some other securities. It is just a market platform you want on that particular platform, and we all know that stock exchange is not just one. We have the main board, we have SMA, we also have IGP, right? Innovators Growth Platform. So sometimes it may so happen that there is a public company which has never given a public offer. It has issued securities on private placement basis. What type of securities? Not equity shares. It has issued debentures, or it has issued preference shares which are never going to be converted into equity on private placement basis, and that security is being listed on a recognized stock exchange. So if that listing is being done, it is not considered as a listed company for the purpose of Companies Act. Ma'am, why? See, because as soon as you get any of your securities listed on a recognized stock exchange and you're being called as a listed company, undoubtedly SEBI will put a lot of regulations for you to comply with. At the same time, Companies Act also gives you a lot of provisions that if you are a listed company, follow this. You're a listed company, do this. You're a listed company, do that. Now, listed company, the whole essence is when you're making that public offer. And if you're not making that public offer, if public is not involved and you have done listing for various other reasons, then in such a case, complying them or burdening them with so much compliances is not very justified. So, ideally, the definition of listed company, Section 2, Clause 52 states that any company whose securities are listed on recognized stock exchange is a listed company. However, there will be certain category of companies prescribed in consultation with SEBI who are not going to be considered as listed. They are public company whose debt securities or preference shares are listed, which were issued on private placement basis. Secondly, private company who have listed their debt securities which they issued on private placement basis. And one more thing, public companies who have issued their securities, they have not listed it in recognized stock exchange, but they have listed it in foreign jurisdiction. So in that case, also such public companies will not be treated as listed companies. Now, what are unlisted companies? The ones which are not listed are unlisted companies. Fine. Nidhi companies. Now, in Nidhi company, again, you have to understand one thing. If in examination it is asked to you what is Nidhi company, you have to write the definition as well as the meaning, because still the institute promotes the meaning only, which has been changed long back. What is Nidhi company? Nidhi companies are, according to the amended thing, Nidhi companies are companies as declared as Nidhi in the official gazette. So we have to make an application and government is going to declare you as a Nidhi company in the official gazette, then you are a Nidhi company. However, what is the essence or what is the meaning of Nidhi company? Nidhi company is the one which is being incorporated for cultivating the habit of savings, the habit of cost cutting amongst its members. Okay, so you have to remember both these things from examination perspective. Next is PFI, Public Financial Institutions, Section 2, Clause 72. In this, you have to remember Life Insurance Corporation of India, LIC, that is IDFCI, UTI, institutions which were notified under Companies Act 1956, and other institution which may be notified. What can be notified? CG can notify any institution as PFI by consulting with RBI. However, there is a particular criteria which must be met, and thereafter only you can notify that institution as PFI. What is the criteria? Either it should be established under central or state act, or at least 51% of capital should be held by central government or state government, or partly by central government or partly by state government. Okay. Next is joint venture. Joint venture may also be called as joint arrangement. Now, there are parties, they have joint control over the arrangements. That means they have joint control or they have joint right over the assets, net assets. Okay, so maybe there are two companies and they have incorporated a third company, they have registered that third company as JV, or maybe without registering also, there could be a JV. Now we come to sectoral companies. What are sectoral companies? Who specialize in a particular sector, like banking companies, they specialize in banking. Insurance company, they specialize in insurance, right? So they also have a sectoral regulator, like RBI regulates the entire banking system. ADA regulates all the insurance companies. So they have a specific sectoral regulator also. So banking company is also a sectoral company. Insurance company is also a sectoral company. If I talk about banking company, they're doing banking business. They have formed a company under Companies Act. They have obtained a license from RBI to pursue banking, and thereafter they are running the company as banking company. In the name of such banking companies, there will always be written bank, so that general public, if they read it, they get to know that okay, this is a bank, right? So they are doing that banking business. The same goes for insurance companies also. Insurance companies also have to obtain license from IRDA, and thereafter they operate as insurance companies, and they also need to have the name insurance. They have also need to have the word insurance in their name, so that people can identify that okay, this is an insurance company. We also have something called as NBFC, that is non-banking financial companies. Now, non-banking financial companies are like banks only. They also do such business as of loans, advances, just like banks do, but they're different from banks. They have certain restrictions, although they are principal businesses of receiving deposits only. They provide, not exactly, they provide loans like housing loan also, or maybe if you have to get a loan for motor vehicle, for purchase of motor vehicle, they'll do that, right? So they do the business of loans, advances, acquisition of securities, leasing, hire purchase, all that. Fine. Now, before we actually go to incorporation part, we have to begin with incorporation. Now, how a company can be incorporated. We also have something called as section number 464 of Companies Act 2013. What does this say? See, if I am starting a business, I have different forms of business organizations which I can choose from. It could be proprietorship, it could be partnership, right? If I choose partnership, how many maximum partners I may have? Well, there is a limit. The limit is of 50. Okay. So if you want to constitute a partnership of more than 50 people and carry out a business for this profit motive, you cannot do that. Why, ma'am? Because there is a section 464 which says that if you want to have such an association of more than 50 people, then you must get it registered as a company. If you don't do that, then what will happen? Then there will be consequences. What will be the consequences? Every member who is there is going to be personally liable. You will not have legal existence. It will be punishable. There will be no power by member to sue. Okay, the member will be entitled to recover money before it is applied for illegal purposes. Of course, this is something which is there. There are two exceptions which you must remember. What are the exceptions? If there is an HF and just capable of being of more than 50 members, then yes, go ahead and form an HF and do business, no problem. And the second exception is like CA firms, CMA firms, CS firms, right? So if you are forming a partnership of professionals and you're being governed by a special act, it could be like ICI, right? So if that is the case, then more than 50 is also allowed. Otherwise, whatever large partnerships you're forming, they have to be registered as a company. Otherwise, it will be called as an illegal association and there will be consequences for the same. Okay. Now, how do we incorporate a company? Right. Any person who generates that idea, who does that feasibility study, who undertakes all the preliminary steps of incorporating a company, that particular person is known as a promoter. If we go by the definition, it is given in section 2 clause 69, wherein promoter could be anyone who is named in the prospectus as promoter, or who is identified in the annual return as as promoter, or who has the control over affairs of the company, whether it by his shareholding or being a director or otherwise, or the board is acting according to whose direction. So that particular person can also be a promoter, and promoter need not necessarily be an individual. It could be a body corporate also, it could be a firm also, right? So promoter could be anyone. Now whoever is taking all that necessary steps at the time of formation of the company, or later on in life subsequently arranges that floating capital or fund requirement, that particular person is also known as promoter, right? So if we begin, there is person or there is a group of persons who are actually undertaking all the steps. They gather the people, they gather the subscribers, they decide which particular business should be done by the company, right? So all that part, whatever is being done, it is done by the promoter. And that is the initial step of incorporation of a company or bringing a company into existence. The first step is what? Promotion of a company, right? Once you do that promotion, thereafter you prepare the documents, thereafter you register the documents for incorporation, you get the certificate of incorporation, you ensure that the funds have been received, and thereafter you commence the business after complying with the requirement of section 10A. So this is the entire process of raising funds and turning on that, right? Starting a company. Okay, so you gather the people, you prepare the basic documents, you may take help of some professional in preparation of documents or filing of documents, but that is not going to be treated as promoters. They are not going to be treated as promoters, right? You initially decide what name of the company should be. You do that filing with ROC. You may also enter into pre-incorporation contracts. We don't have to read them in much detail. Now, before we, I actually, I'll come back to section 3A later. Now, before we actually switch to the process of incorporation, how we are actually incorporating a company, we need to understand about two most fundamental and basic documents that are needed. One is Memorandum of Association, the other is Articles of Association. Memorandum of Association is given in section 4, although defined in section 2, clause 56, but the definition does not give us any real meaning. Right, it only tells us memorandum is what is originally framed and as altered from time to time. So the one that you originally filed, that is also memorandum, and if you have changed it, then subsequently the changed memorandum is also memorandum, but obvious it is, right? However, if we want to understand the meaning of memorandum, it is the most fundamental and basic document of the company, right? Because it tells about the company's constitution. It tells what is the name of the company. It tells where the company belongs to, that is the domicile, the state in which it is registered. It tells what the company can do. The company is being formed to do what, and what the company can do. That means what the company cannot do, what is outside the object clause. That turns out to be doctrine of ultra vires, right? Beyond powers. So it is beyond my power. So object clause also tells me the scope under which I can operate, the purview, purpose for which I'm incorporated, and the maximum scope within which a company can work, right? Next is, what is the liability of the company? Is it limited? Is it unlimited? If it is limited, is it limited by shares or is it limited by guarantee? Right. Thereafter, the capital. What is the maximum capital that a company can raise? Okay, so and its division thereof. So these are exactly divided into different clauses: the name clause, situation, object, liability, capital, and succession clause. Succession clause is not something which is found in all the cases. It is found only in case of OPC, right? Because therein you have the name of the nominee. So in case of OPC, there is just one member who has to give a name of a person who is eligible to become a nominee, who will take place of the sole member in case of death or incapacity of the sole member, right? So that is a clause which is there only in case of OPC. Other than that, the entire memorandum of association has to be signed by all the subscribers. So there will be name of subscriber, address of subscriber, their signature, the number of shares that they have taken in front of their name, and it is all going to be attested by a witness. So there will be a witness, name, signature, everything also. Okay, memorandum of association is divided into paragraphs consecutively numbered. We have a schedule 1 under Companies Act, wherein table A to E are the format ideal memorandum of association for different types of companies, right? So if our company is a company limited by shares, we can pick up that model format. We have to and fill in the blanks, right? The name of the company is, so whatever is our name, we'll fill that, right? Thereafter, we come to Articles of Association. Again, the definition does not tell us anything. Section 5 tells us certain things. The internal regulations of a company for its own governance. Now, again, we have Schedule 1, and from Table F thereon, we have schedules, or we have specific pro forma or format for ideal articles for different types of companies. Table F is something that you must remember because it is a company it is for company limited by shares. Now, again, articles of association is printed. It's divided into paragraphs. It is numbered. It also has a signature of the witness. Right? It has to be prepared for every company. It is required at the time of registration. It can be later on altered. But the most important thing, what is articles? These are the internal regulations of company for its own governance. Supposedly, a company wants to forfeit the shares of its shareholders. Where do we get the rules of forfeiture? So here you have certain flexibility, but you have to write your provisions, you have to write your rules, you have to state your regulations within the act and memorandum. You cannot go beyond the language of the act. If the act does not permit, just by stating something in your articles, it is not going to make it valid. Okay, so within the act, because it is a very apt section, that act is going to override your memorandum and article. So within the act, you can frame your own regulation. So what you can do is, as it is, you can adopt that table F, or you can modify or exclude any clause of table F, right? Now there is a provision called as entrenchment in articles of association. What is entrenchment? Entrenchment is making something more difficult. In usual situations, according to section 14, you can alter your articles by passing a special resolution. However, if you want to add entrenchment to a particular clause, that means you don't want this clause to be changed just by passing SR. So you can put an additional condition that, okay, if you get 90% votes, then only you can change this clause. Or if this thing happens, then only you can change this clause. So when you're putting such a condition, it means you are adding entrenchment. Now this condition can be put, or this entrenchment can be added at the time of formation also, when you're initially preparing the articles, and later on also. So when you're preparing the articles, it is the initial time, it's completely okay, everyone agrees to that condition, then only they are subscribing. And later on, whoever want to become the member of that company, they will read the articles, they will agree to that condition, then only they'll subscribe. But if there are people who have already agreed, who have already been the subscribers, and now you want to add an entrenchment, so you need to obtain their permission, right? So if you want to add entrenchment in a private company, then this has to be agreed by all the members. And if you want to add entrenchment later on by amendment in a public company, then you need to obtain SR, and you will file this with ROC in both cases. Okay, so you'll inform ROC about adding of entrenchment, right? Okay. Now, form for formation of company. How do we actually form a company? How do we form a company? Say, according to section number 3, a company may be formed as a one-person company, it may be formed as a private company, it may be formed as a public company, right? If we talk about section 7, it may be formed for lawful purpose only. And if we talk about section 7, there actually we get the entire process of incorporation. The form that we are using for incorporation is Spice Plus. Now, the Spice Plus is a unique type of form. It is an exceptionally amazing form, because earlier when we wanted to start business, we had to go to so many windows. We had to file so many application forms, obtain this from there, this from there, this from there. This is a kind of single window for starting of business, because when you want to start business, you might need you will need bank account also, you need a PAN also, you need GST registration also. So you need a lot of things. Now, if you want to start a business, what you can do is just file the Spice Plus. Spice Plus is an integrated form, and central government and many state governments have collaborated. So in certain states, if some registration number is mandatory, like you need to obtain a profession tax number in case of certain states. So if you are opening a company in that particular state, you don't need to file a separate application for obtaining that number. When you file Spice Plus, you fill the additional details and you get all of it. So this is a form, Spice Plus plus Agile Pro. Agile Pro is attached for these purposes. So it makes an application for these many. You can get JSTIN, you can get EPFO number, ESIC, profession tax, bank account. They redirect you to the bank account, whichever bank you select. Shops and establishment, you get SIN, PAN, TAN, DIN, and the name reservation is also done. So it collectively offers 11 services in just one single form. So it is a commendable form that has been introduced by the government, right? So this is the form that we actually use for incorporation purpose. Now, when we begin with the process of incorporation, the first step is the name reservation. How do you reserve a name? So, as I told you, the form, relevant form is Spice Plus only. Now, Spice Plus is divided into two parts. One is part A and other is part B. Part A is for name reservation if you want to incorporate a new company. See, whenever you want to incorporate a new company, you have to think of a name. Okay, I want to keep this particular name. Thereafter, this name may be available, may not be available. If it is available, immediately you reserve the name. You block that name, and that name is blocked or reserved for a period of 20 days, which can further be extended to 40 more days. So in total, up to 60 days you can have your name reserved. Okay, and within that you prepare all the other documents and you file the documents with ROC. Option number 2, you don't want to reserve your name pre-hand, you propose a name and file all the documents and give it to ROC. If ROC finds that okay fine, this name can be given to you, they will give the name also and they will give you sin also. If they find that this name cannot be given to you, they will reject the entire application. So it is advisable that first reserve your name, get your name with hand, and thereafter you file other documents. Fine. So the first step is name reservation. If you are a new company, you will use Spice Plus. If you are an existing company and want to change your name, then you will use the web service Run. Right. Okay. Now, you'll file it with ROC. If there is no defect, they'll approve it and they will reserve your name. If there is a defect, they will give you a chance to rectify the same within 15 days. If you rectify the defect, fine. If you don't, they will reject your application. The name is reserved for 20 days, and in case of existing company for 20 days. Here it will be 20 days plus 20 days by giving 1000 additional fees, plus 20 days by giving 2000 additional fees, or directly plus 40 days by giving 3000 additional fees. So this is what extension of name reservation can be done, right? Now, if it is found later on that okay fine, you reserved your name but you gave incorrect information. See, we have read, okay, let's come back and read about this also, recall about this also. There are certain name restrictions. What are the name restrictions given in section 4 along with read with rule 8, rule 8a and rule 8b? What are these? You cannot keep any name you wish to. Your name should not be identical or resemble to an existing company. And there is a rule 8 which actually tells you a huge list that these are not resemblance. So when you want to check resemblance, disregard these. Right. Secondly, your name should not constitute an offense. And thirdly, it should not be undesirable according to central government. Undesirable means you should not use something which is offensive to a section of people. Like maybe you are using some ban Hindu or something like that, right? So it is undesirable according to central government. So you should not use such words. These are completely prohibited. Apart from that, if you want to use a word like board, if you want to use a word like minister, if you want to use a word like panchayat, you need to obtain prior approval of central government. So any such word which gives an impression that you might belong to government needs approval of CG. Plus, there are certain prescribed words, like I said, they also need approval of CG. So, in such cases, Rule 8b, along with this, they need approval of CG. So, once you get approval of CG, then you can use such terms in the name of your company. So, supposedly you haven't obtained any approval from CG, yet you file this incorrect approval and you get that name reserved in your favor. So this means you have reserved your name by furnishing incorrect particulars. Then two situations may happen. One, your company is not yet formed, only the name was reserved. So the reserved name will be cancelled and there will be a penalty of 1 lakh. Second, your name is reserved, thereafter you furnish the documents, so the company is also filed, and later on we come to know that okay, you reserved the name, you got this name by filing incorrect information. So what will happen is ROC is going to give you an opportunity of being heard, and it may direct you that no, change your name within 3 months, or they will strike off your name from the register of members, or they will file a petition for winding up. That means what is happening now, they're saying that okay, all the assets have to be sold, the liabilities will be paid off, everything is going to happen like this, right? Okay, now once the name is reserved, what you can do is If the name is reserved, fine. If the name is not reserved, then also part A and part B together. So that may happen. Now you will prepare all the documents. The documents, as we discussed, memorandum and articles, thereafter declaration of compliance. Declaration of compliance that all the requirements have been met, right? This declaration of compliance will be by the CA, CS, CMA, advocate, and the director. Okay, there will also be a declaration, another declaration that we are not convicted of an offense in the formation or promotion or management of the company. And whatever information we are furnishing to ROC, it is true to the best of my knowledge and belief, right? We have not been involved in the last 5 years in fraud, right, with respect to company law. So this is a declaration which all the subscribers and the first directors, first proposed directors, they give. Next is particulars of office. So you also give your registered office details. Supposedly you do not have a registered office ready at right now, so what you will give is a correspondence address. The correspondence address you will give, and that is fine, because according to section number 12, once your company is incorporated, within 30 days you must have a registered office, and you should have that registered office at all times thereafter, and that has to be within 30 days only submitted to ROC also. So right now if you do not have a registered office, it's completely fine, right? Thereafter you will have all the particulars of all the subscribers, directors, complete details, right? And you also have to have the consent of the directors, their disclosure of interest. Okay, so all these documents are attached, you all the documents are prepared, and thereafter you file part B of Spice Plus along with all these documents to ROC. You will preserve all these documents till dissolution. ROC is going to issue us a certificate of incorporation, allot us a corporate identity number, which is an alphanumeric number, right? Once the company is incorporated and you get SIN, the members become your subscribers. So till the incorporation part, they are only your subscribers. Once the company is incorporated, they become your subscribers. Thereafter, once the shares will be issued, they will become the shareholders. Now if it is found that, oh my god, this is not about name reservation, this is about incorporation documents. So these documents or any information that you have filled in part B, this is incorrect. So you have filled in incorrect information, and the company, for company formation, this is doing fraud in formation of company. So there again may be two situations: the company is formed with that incorrect information, and the company is not yet formed. If the company is not yet formed, you'll identify the people who have done fraud, and you will put in the charges of fraud on those people. But what if the company is formed? If the company is formed, of course these fraud charges will be put on promoters, first directors, and subscribers, but there will be additional orders also may be passed if the application is made to the tribunal. Additional orders like winding up, like removing the name of the company, etc. Okay. Now, some important points with respect to one-person company. Nominee shall give prior consent, which is filed at the time of incorporation, right? Consent may be withdrawn at any time later. Member can change the nominee by intimating company, and the company notifies ROC. The change in nominee does not amount to alteration of memorandum of association. Minor cannot become member of OPC. OPC can't carry out NBFC or investment in securities of a body corporate. At one point of time, one person cannot hold two memberships in OPC or two nominee. However, if he is a member in one OPC and a nominee in another OPC, and by virtue of his being nominee in this particular OPC, he becomes the sole member there also, then within 180 days he has to choose which membership he wants to continue and withdraw the other to meet this eligibility criteria. Right, now we'll go back to section number 3A. Now this tells us that once your company has been incorporated, the incorporation basic minimum criteria was that you must be at least 2 members to form a private company, and you must be at least 7 members to form a public company. But later on also, this membership number should not be reduced below 2 or 7. If it is reduced below 2 or 7, you get a span of 6 months. So if you continue to do business after 6 months also with the reduced members, then every member who know that we are doing business with the reduced members, who is cognizant of this fact, they are going to be severally liable for debts of the company which are contracted after the expiry of 6 months. Right? Okay. Now, this process of incorporation we have done. Now, once your company is incorporated, you get the certificate of incorporation. Can you commence business? The answer is no. You cannot commence business if you are a company incorporated after 2nd November 2018 and you have share capital. Fine. So, if you have share capital, you have to do these two compliances, then only you can start commencing the business. What are the two compliances? Compliance number one, if you have given your correspondence address beforehand, that you must file INC 22 within 30 days of incorporation to ROC, which tells us or which gives the detail of your registered office, right? Second, see, your company has been incorporated. There were the subscribers who agreed that I will take 100 shares, I will take 200 shares, I will take 50 shares. Have they taken those shares? That means, have they actually paid the amount, paid that agreed amount, and the shares have been issued to them? If yes, the director will give this declaration in form INC 20A within 180 days of incorporation. Okay, if they don't give this declaration, then ROC may remove your name from the register of companies. So if the ROC believes that, okay, you are not doing any business, they will remove your name from the register of companies, right? Otherwise, once you comply with these two requirements, that means the directors of the company file a declaration INC 20A within 180 days of incorporation, and you file one INC 22 within 30 days of incorporation. Thereafter, you can commence the business. Okay. Now, this form INC 20A has to be verified by CACS or CMA. If you do not comply, then also you have penalty. You are not allowed to commence business, plus you will be penalized also. Section number 12. Publication of name and registered office. So section 12 says that every company must have a registered office first within 30 days of incorporation. Second, outside every office you will put a board. What will board say? The name and registered office details. It has to be in conspicuous, legible, readable characters, right? Now, if the registrar has reasonable cause to believe that you're not doing business, they will do your physical verification, and if default is found, they will remove your name from the register of members. Okay. Now, alteration of memorandum. We have read about the basic documents. We have read about memorandum. We have read about articles also. Can we change this? The answer was yes. So according to section number 13, we can change the memorandum. How can we change the memorandum? The first one clause is, we have to read about only alteration of these three clauses: name clause, object clause, as well as situation clause. The rest, capital and liability, you read it in the chapter of share capital. You understand it over there, right? Liability clause, let's forget, and that. Now these three clauses: name, situation, as well as name clause, situation clause, and object clause. So first is name clause. Can you change the name of the company? The answer is yes. The company's name can be changed. How can it be changed? By two things: SR and CG approval. Okay. But if you have done a default in filing your annual returns or repayment of deposits, you cannot change the name. So if you have not repaid your matured debentures, if you have not repaid the interest on them, if you have not repaid your matured deposits, you cannot change the name of your company. First, you rectify that default, and then you can change the name of the company. In all other cases, what you have to do is call general meeting, and thereafter pass special resolution, make an application in INC 24 to central government. Central government will grant you an approval that, okay, fine, you can change your name. So that approval and this SR, you will submit it to ROC, and ROC will register your new name and issue you new certificate of incorporation. Very simple. This was voluntary change of name when we wanted to change the name. Second situation is when we are being forced to change our name. When we are being forced, section 16, which talks about rectification of name. So this is compulsory change of name. If I am registered with a company and I have a name, but unfortunately, for whatsoever reason, inadvertence or otherwise, whatsoever reason being, I have registered myself with a name which is identical with an existing company. This comes under name restriction, but somehow it was approved and somehow I was registered. Later on, central government comes to know that, oh my God, this particular company has been registered with the name which is identical or which resemble to an already existing company. So we should get this name changed. So central government will give us a direction that change your name within 3 months. And are we supposed to do that? Yes, you have to do that. So within 15 days, we have to follow by the order. And within 15 days, we will we have to change it within 3 months. When we change, then within 15 days we will intimate it to ROC, and ROC is going to give us a new certificate of incorporation. What if we don't change our name? What if we don't change our name? See, if we don't change our name, then central government is going to give us a new name. So central government will allot a new name, and thereafter we can voluntarily change that name. Okay. The second case is that if I am a registered trademark, and of course nobody knew that I have this particular name registered in my trademark, and if a new company is being incorporated or an existing company changes its name to such a name which resembles to my registered trademark, then within 3 months of incorporation, within 3 years of incorporation of that company, or within 3 years of change of name of that company, I can make an application to central government and ask central government that please give direction to this company to change the name because the name resembles to my existing registered trademark. So what they will do is central government is going to give the direction to change name within 3 months, and that company has to change name within 3 months. And once they change name within 3 months, they will intimate it to ROC within 15 days. Next is alteration of situation clause. See, if we change our registered office from here to here within the same city, it does not amount to alteration. It can be simply done by passing a board resolution and informing ROC in INC 22 about the new office details. Second, if we are changing our registered office from one city to another city, but we are in the same ROC, so you need to have SR, you need to have members' approval by SR, and you need to file INC 22. So you will do these two filing to ROC, and it will be done. If you're changing your office from one ROC to another, but you're still in the same state, that means maybe you're in the state of Maharashtra. Right. So what you have to do is you have to obtain the permission from RD. Although there is an elaborate procedure, but we don't have to get into that. Right. So what you will do is you will make an application to RD, and RD will give you the confirmation. And once you get the confirmation, then within 60 days, you have to inform it to the ROC, and ROC is going to allot you a SIN. Right. Now, the most elaborate one, changing your registered office from one state to another. This amounts to alteration of memorandum, and how is it going to be done according to section number 13? First thing is passing of SR. Second thing is giving an advertisement to people. Third thing is giving individual notices to your creditors that, okay, we are shifting our registered office from one state to another, right? Thereafter, you prepare the list of creditors. That list of creditors is going to be certified by your directors, 2 directors, one of which shall be an MD, or if the company has a company secretary, it will be certified by the company secretary, right? Now, what happens is, now you will make an application to central government for approval that can we shift our registered office from one state to another. So central government will give you an approval, but before they give you an approval, there are a lot of attachments which have to be made. But before actually they give you the approval, they will ensure certain things. They will ensure that you adequate arrangement for the creditors has been made, or you have provided them security, or you have paid off their debts. So after they ensure themselves this, and after hearing all the objections which have been raised, central government is going to grant us approval. Once we get the approval, we will file this approval with the ROC, and ROC is going to issue us a new certificate of incorporation. Then comes your alteration to object clause. See, object clause alteration is very simple. You pass special resolution and you can change the object clause. The only difficult case is that if you have raised money from prospectors, that means you told the general public, you gave a public offer and told them that, okay, you give me money, I'm going to invest in this. This is the object that I pursue. They gave you money and you haven't spent their money, and now you're changing the object to something else. So this you cannot do unless you take their approval by passing SR. Plus, you publish this in the newspaper and give an exit option to the dissenting shareholders. So the ones who do not agree with this change of object clause, change of proposal, you have to give them an exit option as determined by SEBI. Okay. And thereafter you can change your objects. Then comes your alteration of articles. Can the articles be altered? Of course, yes. How can they be altered? By passing special resolution. Okay. Now, there are two broad cases. If you want to convert your private company into public company, it's very simple. You pass special resolution and you will submit SR plus copy of altered AOA to ROC. But if you want to convert your public company into private company, that means right now a lot of compliances you were following, but now suddenly you will become private and the government will not be able to control you so much now. So before that, you need to obtain approval from central government. So this is an additional thing here, and all this is submitted to ROC. Now, once your memorandum, once your articles, everything is being registered with ROC, they become public documents, right? And once your company is incorporated, these memorandum and these articles, they bind members and company. The company is bound to the members are bound to the company. The company is bound to the members means if the company says we are going to not forfeit your shares unless we give you two notice, they are bound by their words. They have to give two notice. The members are bound by the company. If the articles say that all the members have to pay this much amount, if it is called, they have to pay, right? Subject to their liability, right? So company may sue the members for non-compliance, and members may also sue the company in case the company breaches, right? Members are not bound inter se. Although if one member is not doing something, is not paying the call money, this member can get it enforced through the company. So it can say the company that you take money from them. If they're not taking, file an action, file a suit against them, but they cannot directly file a suit. Likewise, the company is not bound to outsiders. These articles, they are internal regulations. If I have said that I am going to keep this Mr. X as solicitor, as my lawyer for life, if I change the articles, that Mr. A cannot file a suit against me. You said that you are going to keep it for life. I did not enter into a contract with you. This was my internal communication with my members. I don't owe on this ground to you, right? So company is not bound to its outsiders. Next comes three doctrines. Doctrine of ultra vires. Ultra vires means beyond powers. So anything which is done outside the object clause of memorandum of association, it is void. Nobody is going to get any benefit of the same. So neither the company nor the contracting party can sue on it. Right. Second is doctrine of constructive notice. Constructive means deemed, and notice means knowledge. So deemed knowledge. So it is presumed that anyone who is coming to deal with the company, coming to enter into a contract with the company, is deemed to have knowledge of memorandum as articles, because they are public documents once they are registered. So it is deemed that they have this knowledge. However, doctrine of indoor management is exactly the opposite of it, which says they are not deemed to know about the internal irregularities or the problems of the company. They know about the articles, but they do not know whether you have followed the articles or not, whether you have passed this resolution or not, right? So this protects the outsiders. However, this also has certain exceptions, like if somebody has knowledge of irregularity, they cannot pretend and say, I am not supposed to know that there is an irregularity. Well, you actually knew about the irregularity. If they're negligent, easily they can find out that there is a problem. But they're like, why should I bother? Right? So, again, and forgery. Forgery is complete nullity, even if you're innocent, even if there is no negligence on your part. Still, if there is forgery, nothing can make it valid. So, it is going to be absolutely null and void. Next comes your Section 8 company. Section 8 company are the companies which are formed for charitable objects or charitable purpose. Right? Okay. So, how this Section 8 company is going to be incorporated in the same manner. The only additional thing is that you also need to obtain a license, but you don't have to make a separate application for obtaining license. The license can be obtained within Spice Plus only. So one single application for license also and for incorporation also. Okay, so ROC on the basis of certain conditions will issue you license also and your certificate of incorporation also, and they can ask you to comply with specified conditions. However, for this application you need to file these documents. There will be MOA, there will be AOA, right? It is going to be different. Now, there is going to be declaration by professionals, declaration by applicant, estimated annual income and expenditure for the next 3 years. This is required for license part. Okay. Now, once you have been given license, this license can also be revoked. When can it be revoked? It can be revoked. Of course, it will be revoked after you give an opportunity of being heard to the company, but it can be revoked if you do not comply with the Section 8 requirements or any associated rules. If you do not comply with the conditions on which license was given to you, if you do any fraud, if you are doing any activity which is violating your object clause. Your object clause said that you are going to promote science, but you're promoting something else, right? Or if your affairs are harming general public. So in such situations, the license revoked can be taken back. Now, whenever license is taken back, license given is taken back, it is not so that you can freely use the money which is there in the company. So there will be additional orders of winding up and amalgamation also, which will go on for public interest, of course, right? However, CG will tell that, okay, fine, now you are not going to enjoy the benefits or exemptions of Section 8 company. You have to you have to add the private limited or limited at the end of your name, and there will be additional orders also. Now, when we come to Section 8 company, the conversion of Section 8 company, see, we have an elaborate procedure rule. We do not get conversion so easily. We need to get the approval of regional director. And to get the approval of regional director, we also have to give a notice. We also have to publish a notice in newspaper. We also have to serve a notice to a lot of authorities. So there is an elaborate procedure. But if we cut it short, first thing, your financial statements and annual returns, everything should be filed up to date. Second thing is you pass special resolution, and for that special resolution there has to be a proper notice along with explanatory statement with proper details of reason of conversion. Thereafter you file an application in INC 18 with regional director for approval. Once that regional director approves your conversion, thereafter you hold a general meeting to pass SR for altering memorandum and articles of association. Thereafter you file it with ROC, and ROC gives you a new certificate of incorporation, right? If any other company wants to become or get itself converted into a Section 8 company, then it has to comply with the conditions specified in Section 8 and apply for license. Once you get the license, then you can change the name, right? Then comes your other conversions like conversion of LLP and vice versa. Now, if LLP wants to convert itself into a company, we get this in Companies Act, Section 366, read with these rules. So LLP can get itself converted into a private company or a public company. How do you do that? You need to obtain approval from the partners. You need to publish an advertisement in newspaper seeking objection. You will take an NOC from the LLP where you are registered. Thereafter, you will reserve your name, and thereafter you will file URC1. There are more details. We are cutting it short and we're just trying to make you recall what the things are, right? So the member details, first director details, LLP agreement, certificate of registration, written consent of all partners, NOC from creditors, NOC from ROC, copy of advertisement, newspaper advertisement. Once you have done all the filing, ROC gives you a new certificate of incorporation, and thereafter you can continue as a company by complying all the requirements of the Companies Act. Now, when you want to convert your company into LLP, these provisions you get under LLP Act, right? So what is going to happen is you are going to hold a board meeting. Once the company or the board of directors decide that fine, we want to convert ourselves into LLP, you will also take consent from the shareholders. You'll file a form for name reservation. Thereafter, you will file necessary documents for incorporation of LLP, E-Form 18, along with these. So statement of shareholders, statement of assets, liabilities, verified by auditor, list of creditors with their consent, director details, and more. So once you do that filing, thereafter you get the LLP incorporation, right? Okay.